Hello all, my name is Tanvi Thapliyal. I am Assistant Professor at School of Law and Legal Studies, Sage University, Bhopal. Today's topic of discussion is basics of intellectual property rights. Primarily, it is important for us to know as to what are the kinds of properties. So, a property can be of two kinds: tangible property and intangible property. Tangible property is a property which we can see, touch, and feel. Like if there is a car, if there is a book, if there is a pen, if there is a building, we can see that building, we can touch that building, we can feel that building. Likewise, intangible property pertains intellectual property. Like if there is a copyright, if I write a poem, I cannot see that poem, I cannot touch that poem. It is an output of my intellect. So these forms of properties, these forms of intellectual properties are intangible kind of properties. Moving on, what are the types of IPRs? So the spectrum of IPRs are very broad in nature, but primarily there are five kinds which we'll deal with. One is patent, second is copyright, third is geographical indication, fourth is trademarks, and fifth is industrial designs. Apart from these five, there are traditional knowledge oriented IPRs, there are trade secret oriented IPRs, but these five are the most important forms. Now the question arises that when we have legal rights, when we have fundamental rights, why intellectual property rights are specifically dealt with? So the answer to this question is that these forms of rights are person oriented. These forms of rights are not given to each and everybody who is existing in the territory of India. These are exclusive rights which are given to an exclusive person for a certain period of time. Secondly, it comes under the ambit of legal right. Why legal right? Like for example, I have a copyright over a poem of mine. If somebody else basically does theft over that copyright of mine, I can take legal action against that specific person. Third is it is intangible potential asset. Asset means an economic value is added to that specific intellectual property. So I cannot see that specific intellectual property. I cannot touch that specific intellectual property. It is a creation of my mind, my intellect, but it is gaining me, giving me a certain economic benefit. Third is monopoly. Monopoly means but obvious. There is one person who has all the rights inclined to that specific object or that specific property. So monopoly is one of the criteria. When a person has exclusive right over his intellectual property, he automatically gets monopoly over that specific intellectual property for a certain period of time. Now, negative rights, that is, it prevents others to use his or her creation for a definite time. Like, for example, if I make a pharmaceutical drug, I get a patent over that drug. Over that specific patent, I have exclusive right for 20 years. Now, when I have exclusive right for 20 years, it creates a positive right for me. Like it is giving me right that I can enjoy that patent for 20 years, but it is creating a negative rights for others. Like it is preventing or barring other people to use my patented product, my patented intellectual property. Moving on, why does IPRs got recognition? Now, like I said earlier, when we already had fundamental rights, we had legal rights, why IPRs? So, there are mainly four criterions, four major reasons why intellectual property rights got recognition. But obvious, in our day-to-day life, we think something new, we have new ideas coming up, but uh, it happens very less number of times that those ideas get recognition or a form of incentive. So intellectual property rights give rights to a specific person, but along with certain rights, it also provides certain incentive in forms of money to that individual. With incentive, it gives certain recognition to a person that for 20 years, a patent is yours. For 60 years, a copyright is yours. So it is providing a recognition to that specific person. It ensures a material reward. It is not saying ki, Like, it is very good that you created an intellectual property, gave a certificate, and end of the discussion. No, it is ensuring a material reward by basically, if there is a poem I wrote, I can sell royalty of that poem. If there is a song I compose, I can uh, I can earn a royalty out of that specific song. So there is insurity of a material reward inclined to that intellectual property of mine. Now, to make available genuine and original products. But obvious, if I have a patented pharmaceutical drug, if I get it manufactured, I'll make sure that the manufacturer manufactures it genuinely and originally, because if it is not so, then my product will get defeated in the market after a certain period of time. Now, types of IPRs we discussed earlier, also patents. Like, what are patents? The patents are basically inventions. Any innovation, any invention, any novel idea that leads to a formation of a product or a process or a composition. Any technical solution to a technical problem gets patented. Like, for example, if I make a pharmaceutical drug, the salts used in it, the composition of the salts, it can get patented. The process through which I am getting that drug made can be patented. And ultimately, the output of that specific research, the product, it also get patented. Then comes industrial design. Industrial design is all about आपका external feature. External feature means, like, there is a Coca-Cola bottle. So we know the shape of a Coca-Cola bottle. Like, if I am sitting if I am sitting 10 meters away from a Coca-Cola bottle, the glass one, I can easily distinguish a Coca-Cola bottle from a Mazda's bottle. Why? Because of its external feature, because it is appealing to my eye. So any new shape, pattern, or configuration makes an industrial design. Then comes trademarks. Like, for example, Sage University. Okay, Sage University, our our logo, the name, the word Sage, all these things are the marks inclined to this trade. Okay, now coming on to next is copyrights. So copyrights are like artistic, literary, musical, and dramatic creations. Any poem I write, any artistic, any drawing I do, any musical composition I make, the day I write that musical composition, the day I make that drawing, from that day itself, I have a copyright over that specific product that is coming out of my intellect. Like, it comes into existence as soon as the work is created. Then last one is geographical indication. As the name suggests, geographical indication. In intellectual property which is indicating a certain geography. Like, there is Chanderi silk sari inclined to the area of Chanderi. The manufacturers there, they might be having certain method, they might be having some form of process involved into making of that specific Chanderi sari. So it is getting a geographical, it is indicating the geography of that specific territory, hence it becomes geographical indication. Basically, in order to promote the traditional knowledge of a certain area, these geographical indications comes into existence. Then, what is the organizational structure? Like I said, patent and design, we can get a patent. I can get a trademark. If I want to start a company, I can get a trademark of that specific company. But from where is the question which arises, and not many people know. So organizational structure is intellectual property rights comes under the Ministry of Commerce and Industry, Department of Industrial Policy and Promotion. Secondly, the authority which controls intellectual property right is Controller General of Patents, Designs and Trademarks. And these are the enlisted offices of the same. Like, for if you want to get a patent, you can apply to these four places: Kolkata, Delhi, Mumbai, Chennai. There is an online form available. You can, through that online form, you can apply for a patent and a design. Secondly, a trademark registry in Mumbai, Kolkata, Delhi, Chennai, Ahmedabad. Once again, you can go online and you can register your trademark through a form given there at the trademarks registry. Geographical indications registry is established in Chennai. Patent information system is in RGNIIPM Nagpur. Now, valid period for an IPR. Like I said, for a patent, it is 20 years. Maximum protection is 20 years. After 20 years, my monopoly over a patent of mine stops. Why so? Because it needs to come in a public domain. If there is a pharmaceutical drug, if it is patented by me, I have used that patent for 20 years. Now I can't kept on using for n number of years because it needs to come, the process needs to get into public domain. So patent has maximum protection of 20 years and the renewal is mandatory to be done every year. Trademark exists for lifelong. It just need to get renewed every 10 years. Design has a maximum protection limit of 15 years. Every After 10 years, it can get renewed for next 5 years period of time. Copyright, maximum protection for copyright is 60 years. Renewal is not required. Geographical indications are again protected for lifelong and are needed to be renewed every 10 years. In case of patents, once the renewal is due within 6 months of time period, that specific renewal is mandatory to be made. Last but not the least, if you want to understand as to what different IPRs are like, it could be understood by one simple example of a Coca-Cola bottle. We have all seen this Coca-Cola bottle. The logo Coca-Cola here is example of a trademark. The way it is written, the cursive writing, all these things are the trademark of that specific Coca-Cola bottle. Then comes the shape of the bottle. The shape, the inclinations, everything is the industrial design. Then comes patent. So what composition makes that carbonated water is a patented process done by Coca-Cola. So patent may have been obtained in respect of the bottling equipment. Then copyright in respect of the text, database or artistic work appearing on its website. Anything which is appearing on its website, or maybe the way this Coca-Cola is written, maybe the word Coca-Cola is something which is a copyrightable intellectual property right. So in this way, by means of one example, we understood how different IPRs can exist into one single product. Thank you so much. I hope you like this lecture of mine. If you have any suggestion, you can comment those in comment box. Please like and subscribe my video. Thank you so much.